begin in 5, 4, 3, 2, 1.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we want to welcome Mr. Stevens and Mr. Rollins to this oral argument, which is being live streamed so that we can fulfill our obligation to the public to maintain open courts. We will conduct the hearing in the same fashion as if we were all in the courtroom together. And the appellant has reserved 2 of his 15 minutes for rebuttal. And of course, the appellee gets 15 minutes as well. Unless there are some announcements, I'll ask Ms. Lindsay to call the case.
Los Pumas Concrete versus Harmony Hospitality, LLC et al.
All right, you have the floor, counsel.
Very well. May it please the court, Kevin Stevens of the Knoxville Bar, and I represent the appellant, Harmony Hospitality, LLC. This appeal arises from a construction payment lawsuit initiated by the appellee, Los Pumas, a concrete subcontractor for the construction of a hotel project in Nashville. Appellee filed suit against both Omni Construction Company, the contractor with whom it was in privity, as well as the appellant, Harmony Hospitality, LLC, the owner of the project. At the trial court, appellee originally obtained a default judgment against Omni in the amount of $156,000. Now, Omni did not defend against appellee's claim because Omni had abandoned the project back in April of 2018 and entirely gone out of business before the project was completed. After obtaining a default judgment against Omni, appellee sought to obtain a duplicative judgment against appellant for unjust enrichment and lien enforcement. In moving for summary judgment, the appellee glossed over the fact that nearly all of the work it was claiming fell outside the scope of its subcontract. In fact, the appellee's claim related almost entirely to 13 separate disputed change orders, each of which was essentially a separate disputed claim. In response to summary judgment, appellant raised a litany of disputed material facts, not the least of which was the fact that the 13 disputed change orders were not authorized. Moreover, they raised countless disputed facts regarding the amounts claimed by the appellee for this unauthorized work. Despite all the disputed material facts, the trial court awarded summary judgment against appellant for $192,000. Now, I want to briefly summarize the disputed material facts that were raised in response to summary judgment. Appellee again moved for summary judgment based upon the 13 separate disputed change orders. And in response, the appellant submitted an affidavit from its managing partner, Mr. Amit Patel. Based on the Patel affidavit, appellant disputed the following material facts. First, appellant disputed that the 13 change orders were ever authorized, as none of the change orders were in writing in accordance with the requirements of the appellee subcontract. Second, appellant disputed that the work subject of the 13 change orders was even completed because all of the disputed change orders were dated after Omni abandoned the project in a time when no work was being completed. And third, appellant disputed the amounts charged by appellee for the 13 change orders because there was a nearly $100,000 difference between appellee's own final verified pay application and its own notice of non-payment. Appellee's final verified pay application claimed only $48,627 for work completed on the project through May 31 of 2018. Yet in its notice of non-payment submitted just 6 days later on June 6th of 2018, it claimed $144,000. And Mr. Patel's affidavit made clear that the project was abandoned and no work was being completed during this time span.
Now, didn't the subcontractor offer some proof that that third pay application was not completed correctly?
There was no proof. The only proof they offered was a self-serving conclusory affidavit from its owner that it completed all the work that it was claiming, but it never made any explanation for the mistakes or errors in its own pay application. So there was nothing to clarify why its pay application sought one amount, yet its lien filed within 6 days later sought a completely different amount. And that clearly raised a major disputed issue of material fact that wasn't taken into consideration on summary judgment.
Well, I thought the subcontractor offered some proof that they relied to some extent on Omni to complete the pay applications after they submitted. Is that not in the record?
There was one paragraph in the record that they relied on Omni to help them in that process. You're correct, Your Honor. However, there was nothing to explain the discrepancy and the fact that they submitted a verified pay application signed by their own owner on May 31, seeking $46,000 or $48,000. And then 6 days later, they signed their own notice of non-payment seeking $144,000. So there was no clarification as to why such an error was made or verified by the subcontractor directly. With respect to the first issue on appeal is that the pay applications contain these numerous errors, which we were touching on. Again, appellant raised multiple disputed facts regarding the discrepancy between the pay application and the notice of lien, which was filed within 6 days. And just one, in addition to that inconsistency, there were inconsistencies on the face of the pay application. Just one example was that the appellee billed twice for the same swimming pool concrete work, representing an undisputed overcharge of $17,760. And this was not addressed on summary judgment, and the trial court made no finding relative to this inconsistency. So relative to the lien claim of $144,000, at least $113,000 was disputed based on appellee's own accounting errors. And this should have been a matter for the court, the trial court, to consider and take testimony so that it could weigh the evidence to determine the scope of these billing errors and determine whether or not this work was even completed. So on summary judgment, there were 5 totally different amounts claimed. Claimed $48,000 on its verified pay application, $144,000 lien. It got a judgment against Omni for $156,000, got a judgment against the appellant for $192,000, and it even submitted an affidavit from an appellee's owner claiming $197,000. So there was a complete discrepancy in appellee's own billing claims, which should have been resolved based upon testimony, and the trial court should have had an opportunity to weigh the evidence as well as the testimony of both parties.
Wasn't one of the discrepancies resolved? I think it was the amount of rock or soil that was either removed or brought to the job site.
There was one concession during the course of summary judgment that they acknowledged that there was an overbilling for roughly $5,000, and that was the only resolution on summary judgment, Your Honor. With respect to the second issue is a waiver of the express change order requirement. The subcontract expressly stated that only Richard Stone shall have authority to execute change orders. And significantly, the subcontract also stated that the agreement may not be modified or amended except in writing signed by the authorized representative of the contractor. And no course of conduct, act, or omission shall constitute a waiver of this provision. It's undisputed that none of the 13 change orders were signed by Mr. Stone. And in fact, many of the change orders were completely unsigned and many were undated. The trial court erred in failing to consider TCA 47-50-112C, which prohibited oral modification of the subcontract's written change order, and specifically says, if any contract contains a provision to the effect that no waiver of any terms or provisions shall be valid unless such waiver is in writing, no court shall give effect to any such waiver.
And that statute was brought to the trial court's attention?
The statute was not brought to the trial court's attention in briefing because there was some question about which law applied. The contract applied Ohio law, but then after the fact, a statute stated that it was improper to apply a law outside the forum state where the construction appeared. But although it wasn't...
Didn't the trial court at least implicitly consider the oral modification based upon a course of conduct principle? Because the trial court made a specific finding that based upon the course of conduct of the parties, the contractor and the subcontractor, they had waived that written signing by Mr. Stone.
That's correct, Your Honor. The trial court did make that finding based on a bare affidavit from a former employee of the subcontractor who just testified without stating anything further that the parties orally agreed. He didn't say who orally agreed, when it was orally agreed, who was there for that discussion, and notwithstanding any oral agreement, it violates TCA 475112, which plainly states that there cannot be an oral modification in where the contract provides that it cannot be modified except but in writing. And so, admittedly, TCA 475112 was not raised, but we cited in our reply brief that it's the duty of the court to apply the controlling law, whether or not cited or relied upon by the parties at trial.
Isn't there a legal distinction between oral modification and course of conduct modification?
There is, Your Honor, but this subcontract expressly addressed both and said no course of conduct, acts, or omissions shall constitute a waiver. So I think the express language in this subcontract should control. With respect to the final two issues raised on appeal, those both relate to the unjust enrichment claim. And we cited in our brief the Pascal case, which is the leading Supreme Court case that said, if a landowner has given any consideration to any person for the improvements, it would not be unjust for him to retain the benefit. So therefore, any payment of any amount to any person by the appellant for the work performed by the appellee negates a claim for unjust enrichment. In this case, it was undisputed that based on appellee's verified pay application, that it received $245,000 of the $294,000 that it billed under its subcontract. So we respectfully submit that the appellee had already received far more than just any consideration. In fact, it received 83% of its total billings. And based on the Pascal case, the fact that the owner paid the contractor all amounts billed on the invoices, which included the subcontractor's billings, that negates a claim for unjust enrichment. The last issue related to unjust.
Did I hear you say that your client paid 83%? What was the percentage?
Ultimately, it was 83% of what was billed on the final pay application. But in fact, based on the standard from the Pascal case, if it paid anything, in fact, for the work completed by the appellee, an unjust enrichment claim does not lie. So this in fact was substantially more than the bare minimum.
Your client paid $10 for work on this project. Couldn't assert an unjust enrichment claim?
I respectfully submit that the plain language of the Pascal says any consideration to any person for the improvements. And we cited in our case the Whitehaven Community Baptist Church case that was specifically in the construction context. But I think given the fact that we're talking about 83% of what was billed, I think that's substantially higher than the standard set forth in Pascal. And the final issue on unjust enrichment is that a party seeking recovery is limited to the value of the goods or services and not their contract price. And the Forrest versus Laughlin case says courts will not award unjust enrichment without some proof of the reasonable value of the goods or services. And the party seeking to recover unjust enrichment has the burden of proving the amount by which the improvements enhance the value of the land. In this case, the appellee submitted no evidence on summary judgment that it improved the value of appellant's property at all, much less that it improved it by any amount beyond the $245,000 that had already been paid. Therefore, we submit that they failed to meet their burden of proof for any claim for unjust enrichment because they provided no proof other than their own billings that they actually enhanced the value of the property, and certainly no proof that they enhanced it beyond the amount which they were paid. So that was respectfully in error at the trial court level.
Thank you, Mr. Stevens. We'll hear from you further on rebuttal. Mr. Rollins, the floor is yours.
Thank you. This is a fairly simple case where Harmony contracted with Omni to build a hotel, and Omni subcontracted with Los Pumas to perform concrete and related work. Los Pumas did the work. Omni experienced financial troubles and pulled off the job. Los Pumas was left unpaid for contract and change order work already performed when Omni pulled off. This litigation ensued, and then the motion for summary judgment was granted. I will intend to address Harmony's arguments in the order that they made them in their brief. Harmony's first argument is essentially that there's an accounting issue, and this creates an issue of fact. First, they say that the pay application number 3 was different than what the lien amount was. The pay application number 3 did not include all the change order work. Further, as I believe Judge McBriar stated, that there was proof in the record that Los Pumas relied on Omni to fill out these sophisticated pay applications. That does not mean that the amount requested in the pay application was incorrect. Mr. Stevens points to a double billing on a pool. This is an example of an unsophisticated subcontractor not knowing how to fill out this sophisticated pay application. That doesn't mean that the amount is incorrect. Early on in this litigation, a lien was filed in the amount of $144,067. This was based on the early discovery and the documents that we had at the time. A default judgment was then granted against Omni for the same amount as the lien plus interest and attorney's fees and roughly $11,000. That does not create an issue of fact. At the motion for summary judgment,
Mr. Rollins, does it matter how much the plaintiff received against Omni in its judgment when we are considering what Harmony does or does not owe to the plaintiff?
if I understand your question correctly,
Well, the judgment that's against Omni, does that tie the plaintiff's hands to pursue its claim?
I don't believe so, and they haven't cited any case law or statute that says that. And that was early on in the litigation. As your honors know, to pursue an unjust enrichment claim against an owner, you have to first exhaust your remedies against the party to which you have a contract with. This default judgment was granted very early on. And after discovery and sitting down and going through all the documents with the client, we realized that the amount was a little bit more. The amount is the total of the pay application plus the change orders that were attached to the Michael Sanford affidavit. If you add up all those numbers, you get to $183,434.72.
I apologize for interrupting you again, but let me state my question a little differently. The judgment that the plaintiff obtained against Omni was based upon the contract between the general contractor and the subcontractor, while the present dispute is an unjust enrichment claim between the plaintiff and the owner of the property. Is that right?
Yes, and a lien claim.
Okay.
And at the motion for summary judgment stage, I wouldn't call it a it is a concession. There was, to avoid an issue of fact, there was 106 loads of soil that were hauled off the property. The Sanford affidavit said that he saw 75 loads of soil being driven off. To avoid an issue of fact, Los Pumas conceded that for damages purposes that it would just go with the 75 loads. And that's where you get the number in the motion for summary judgment. The court also granted us 10% in fees.
So Harmony here never raised judicial or equitable or collateral estoppel as a defense here based on the judgment against Omni.
No.
Okay.
Moving on to Harmony's second argument, which is that Los Pumas and Omni did not waive the written change order requirement. I'm also going to walk through many of the arguments that Harmony asserts for the very first time on appeal. It's important that this Court of Appeals not allow Harmony to do so. Tennessee law is crystal clear that issues raised for the first time on appeal are waived, and a party may not now use his own failure to act to obtain a more favorable decision on appeal. Black v. Blunt, 938 Southwest 2nd, 394 at 403. This area of the law has been described as a cardinal principle. Waters v. Farr, 291 Southwest 3D, 11.3 at 918. Harmony makes arguments about the swimming pool accounting and pay app 3, the value of the lien and the values of the amounts and the pay apps are different, and that the default judgment amount is different than the motion for summary judgment amount. I've gone through some of those already, but they didn't make these arguments at the trial court level. There's no law or facts that support these brand new arguments that they've cited. In any event, like I said, the default judgment and the lien claims are the same. The default judgment simply added interest and attorney's fees. Both the default judgment and lien were entered early on in the litigation. The motion for summary judgment amount is correct in that it added pay app 3 in the change orders and invoices up correctly, and the court also gave interest.
What proof is in the record as to the value of the services rendered by plaintiff, or the improvement in the value to the owner's property directly resulting from the plaintiff's work?
The affidavit of the owner of Los Pumas and the affidavit of Michael Sanford. It details what the work was done and the amounts that was furnished and how much it cost. The Sanford affidavit attaches change orders and invoices. The change orders and invoices detail what was done. For example, the soil change order, it listed 106 loads times $720 per load, and at $76,320. That work was done. It's sworn to by both Mr. Sanford and the owner of Los Pumas. I think that defines the reasonable value of services. I also think it's important to note, I was going to get to this point later, Harmony didn't make that argument at the trial court level. And that argument shouldn't be asserted on appeal under the case laws that I cited earlier. Harmony also cites to TCA 4750-112C and related case law stating that a waiver cannot occur if the contract includes provision stating such. Again, this wasn't argued at the trial court level. Mr. Stevens said it wasn't in the briefs and it wasn't mentioned at oral argument either. Cookeville Regional Medical Center v. Humphrey is directly on point, as the Supreme Court held that given that Harmony failed to raise a statutory argument at the trial court level, then the court will decline to address it on appeal. 126 Southwest 3D 897 at 905 through 06. In any event, this argument is flawed because Harmony admits that it applied Ohio law at the trial court level, but now seeks to apply a Tennessee law at the appellate level. It's clear that Tennessee law applies given TCA 6611-208, which states that for contracts to improve real property in Tennessee, Tennessee law applies no matter what the contract says. Harmony is asking the court to fix its error on appeal, which is not allowed under Rule 36 because Harmony has failed to take action necessary to cite the law it now cites for the first time on appeal. Also, Harmony admitted in its corporate representative deposition that it wasn't in the loop as between dealings between Harmony and, not Harmony, Omni and Los Pumas, the general contractor and the subcontractor. Further, Gary Clay, the party that signed off on many of these change orders and invoices, was an authorized representative of Omni. The provision in the contract that Harmony relies upon does not define authorized representative. And Gary Clay was a superintendent for Omni. This is undisputed. Many of these change orders were signed by him. And it's very clear that he had apparent authority to act on behalf of Omni. A case that's directly on point is Century Fire v. Flowers Holding. It's 2010, 10 App, Lexus 575 at pages 6 through 7. Further, it's undisputed that Richard Stone was never on site, the party that Harmony says is the only one that can sign, as provided in the contract. Harmony was also aware that Mr. Clay worked for Omni, and Harmony's authorized representative's deposition, like I said that Harmony did not approve any subcontract change orders because Harmony would not be in the loop for subcontract change orders. Lack of knowledge does not equate to a disputed fact. Therefore, we have a signed writing by an authorized representative of Omni that modified the contract, as did the course and conduct of the parties, as Judge Clement mentioned earlier. Another argument that Harmony makes for the first time on appeal is that in its reply is that Michael Sanford's affidavit contains hearsay and therefore cannot be relied upon. This wasn't alleged at the trial court level again. And in any event, Michael Sanford was in a meeting with the players from Omni, including Rob Wook, Gary Clay, and Richard Stone, where Richard Stone provided Gary Clay authority to sign change orders. Harmony states this is inadmissible hearsay. To the contrary, this is an opposing party admission by an employee of Omni. Tennessee Rules of Evidence 803. Omni is a defendant in this matter. It's clearly.
Let me step back for a second, talking about Gary Clay's role here with Omni. I know that you mentioned it, that you said it was undisputed that he was the area superintendent for Omni, but actually Harmony disputed that. They said it was undisputed he was an employee of Omni, but then dispute that he was an area superintendent. But then strangely, they rely on Mr. Patel's deposition as showing that that's a disputed fact, which I'm assuming Mr. Patel, as the owner of Harmony or an official of Harmony, wouldn't know did he have any knowledge of who was serving what role within Omni? Mr. Patel.
It's clear in the record, and I might have misspoke. It was undisputed that he was an employee, but I believe in Sanford's affidavit, he says that Gary Clay was an area superintendent. Michael Sanford was an employee of Omni. He would know who it was. And I believe that Mr. Patel's affidavit, a little self-serving, never said that definitively what his job title was.
Yeah, I'm just wondering how the trial court might have relied on that as creating a factual dispute when Mr. Patel wouldn't have any knowledge about what the positions held at Omni were.
Okay. I think the fact that he was an employee, I think that's enough.
Okay.
Harmony's last two arguments discuss unjust enrichments, which Los Pumas is going to address this one issue. Another argument that Harmony makes for the first time on appeal is that we didn't prove the reasonable value of our services. We discussed this a little bit earlier. Since it was not alleged at the trial court level, it shouldn't be considered on appeal. In any event, Los Pumas did prove the reasonable value of its services through the affidavit's owner and Mr. Sanford, attached pay apps and change orders to Mr. Sanford's affidavit. Therefore, Harmony's argument that Los Pumas did not prove the reasonable value of its services lacks merit. Next, Harmony has failed to show that it paid Omni for all the work of Los Pumas. Harmony's argument is that it always paid Omni in full is nonsensical related to this issue. It is undisputed that Harmony did not pay the last pay application to Los Pumas. It's undisputed that Los Pumas' work was timely and free of defects. It is clearly unjust for Harmony to retain the labor and materials that Los Pumas incorporated into the project without paying Pumas. And as Justice McBrayer or Judge McBrayer said earlier, it's nonsensical for them to rely on Pascal's, which I think it's a misinterpretation, to say, well, we paid the general sum money, so we don't have to pay the sub everything it's due. You mentioned, you say pay them $10, and he's saying the reading says that. I don't think that's correct. Los Pumas is entitled to the amounts it was not paid under its unjust enrichment claim. Moving on, and more of a conclusion, Harmony's fatal flaw in this matter was failing to obtain any evidence to rebut the Sanford affidavit. Affidavits are taken as true. There is nothing in the record that rebuts Mr. Sanford's affidavit that states that Los Pumas performed the work and that Gary Clay was permitted to sign off on change orders because Richard Stone was not on site and gave him that authority. In Harmony's brief, it states, and I quote, Harmony believes that, insert Mr. Clay, had no authority to approve or authorize change orders on behalf of Omni. The key word is believe. Ryby Women's Care Center of Memphis PLC provides that Harmony must do more than simply show that there's some metaphysical doubt as to material facts and point to facts in the record that could lead a trier of fact in Harmony's favor, which it failed to do. Also, they had an avenue for relief that they didn't use, and the trial court said this. On a Rule 5607, they could have asked the court for more time to obtain affidavits, discovery, depositions to try to rebut the Sanford affidavit. They did not do that.
All right. Thank you, Mr. Rollins. Your time is up. Mr. Stevens, you have 2 minutes for rebuttal.
Very briefly, thank you, Your Honor. The issue raised that we didn't pay the final pay application to the subcontractor misapplies our contractual obligation. We were obligated to pay the invoices from our general contractor, the contractor with whom we're in privity. And the undisputed testimony from Mr. Patel in his affidavit was that Harmony Hospitality paid each and every invoice submitted by the general contractor in full. So that in itself satisfies its contractual obligation and negates an unjust enrichment claim by the subcontractor with whom it was not in privity. With respect to their argument that we waived issues on appeal, particularly the application of TCA 4750-112, we certainly argued the plain language in the contract which prohibited any oral modification of the written change order requirement in the subcontract. The fact that TCA 4750-112 was not applied, that was an error that the trial court can be remedied on appeal because it's the duty of the court to apply the controlling law. We certainly raised the issue of non-waiver, and at the trial court level, there was a dispute as to what law was controlling, whether it be Ohio or Tennessee. But ultimately, we're entitled to rely on this statute because we raised the issue at the trial court level that they could not waive the written change order requirement in the subcontract. And the language of the subcontract is unambiguous because it says requirements cannot be waived through oral modification or through conduct. And so that is expressly prohibited. The trial court's finding that waiver was through conduct is expressly prohibited by the plain language of the subcontract itself. With respect to unjust enrichment, again, they provided no proof of the reasonable value of the services at the trial court level. And obviously, based upon the ever-shifting amount of their claim, there certainly was no basis for the trial court to find a clear finding in that regard.
Thank you, Mr. Stevens and Mr. Rollins, for your arguments. We will take this matter under advisement. Ms. Lindsay.
This Honorable Court of Appeals is now in recess.
Thank you. And counsel, you're free to exit the meeting.
Thank you, Your Honors.